Hello, everyone. It's nice to see so many people. Our LinkedIn Live is growing with every every iteration. We have more and more speakers. This is amazing. Christina and Laura, welcome. We are so happy to have you guys today. Thank you so much for taking the time.
Thank you for having us.
Absolutely. Right. Laura is with us the second time around. And Elena, I guess you can do a quick introduction, and then I'll introduce Christina as well.
So Laura, as you guys all remember, is a brilliant AI ethicist and a brilliant businesswoman, and all around perfect and just amazing human being who was kind enough to join us today for the second time. And we're thrilled to have her and tons of stuff to discuss today.
Right. Yeah. And Christina is graciously also joining us today. And Christina actually coming from the business and art world. She has more than a decade of experience in finance industry, leading startup with leveraging blockchain technology, and currently right now Christina is the CEO of the Tech Diplomacy Network, which was launched to foster collaboration and dialogue between the diplomatic community, civil society, tech industry in the San Francisco Bay Area and beyond. And prior to that, Christina was the director of the Contemporary Art Fair in Vienna, and she also worked in Russia, and Christina has a business degree in international business, and also she has a master's degree in contemporary art from the Sotheby's Art. So we kind of have this like unique set of experiences and skills. And because we're going to be talking about international initiatives as well as like copyright and AI, and Christina will bring that unique perspective from the business, art, and kind of tech combination of knowledge and experiences. So welcome and thank you for joining us today.
Thanks.
All right.
I'm excited to join the talk of AI and real life. I love the real life aspect. Thanks for having me.
Yeah, that's the goal, and I always run the slide before we start, so the folks who have just chimed in. So our talk is not about this. It's not about apocalyptic events or existential threats of artificial intelligence to the humankind. It's more of a what we're doing right now, and how this technology affects our real life and why we should care. So today we thought about focusing on three major kind of topics around this. So last time when we were left off, we were started to discussing OECD AI definitions, just basically what is AI, because everyone's talking about it, but somehow it has to be structured and spelled out. And we'll talk about this definition that will likely, make it into the European AI Act. We'll see about that, but that's probably going to happen. Then we'll talk a little bit about AI copyright. I know that's a huge area. We're not going to cover it all, just some recent developments about the lawsuits in the artistic and literary world that we're seeing. And also then we'll switch and talk a little bit about AI generated works detection, deepfakes, watermarking, and some of the initiatives and some of the legislations that existing there today. So with that, I guess we'll start talking about this first topic, and just kind of trying to unpack that AI definition that Organization for Economic Cooperation Development just came up. And this is how I broke it down, but you're welcome to expand on that, because this is really very generic, but this is something that I think we can work with when talking about what actually artificial intelligence is from, legal standpoint or, business perspective. Yeah.
Well, I think it's essential that we have, and I think from a legal perspective, you'll agree, it's important to actually have a definition of what we're talking about when we talk about regulation, and exactly what's going to, one of the reasons why definitions come in handy is because it tells us exactly what's included and what's excluded. So it has to be specific enough to include the right things, but also make sure that it's not such a broad and general definition that everything and anything can fall under it. So I think one of the reasons why, even though it seems like a very kind of academic kind of consideration, like, oh, let's define this, in this context, because we're talking about regulation, it really does matter. It literally has to do with what the regulation is going to apply to and what it won't. And of course, a machine-based system that can, for a given set, have human-defined objectives or needs, make predictions, recommendations, or decisions that influence our real or physical environments, or even in a virtual one, seems to kind of roll up a decent amount of, well, and I'm sure as their intention is to kind of sum up AI and what would fall in it, so that when we do create regulation and we say, hey, we're talking about AI, somebody can't come back and go, but you're not talking about me. Now, they'll still try and say they don't fit the definition, but at least with a clear-cut definition, we now kind of have a yardstick with which to evaluate which systems fall into possible regulatory frameworks and which ones do not, as long as they recognize the OECD definition.
Right. And yeah, I think that from what I learned recently, and I think that the intention is to actually take this definition and incorporate it into the upcoming EU AI Act. If that act is going to happen, because I think that the negotiations, so to speak, hit a some sort of an obstacle, right, Elena? Just recently, yeah.
Hold on 1 second. Can somebody go to LinkedIn right now and click on our event and tell me it's really live? Because I'm seeing it says pre-live and it's not live. So it's either just me, because I'm seeing us talking on my LinkedIn page, but I don't know. I'm not sure. Here it says we're live streaming, but I just wanted to make sure on the other end. Are we?
It says live.
Oh, we're live, right?
It says live.
Perfect. Thank you. Because just I can't see our video here. Yeah, live. Yeah, I see comments. Thank you so much, guys. Because just, yeah, I kind of got confused for a second. I'm so sorry. Just wanted to make sure we're not kind of talking to each other. Just us. Okay. So sorry. Let's go back to the OECD.
Right. No problem. Yeah, so I was just saying that this definition might be important because it might be actually incorporated into European AI Act if this AI Act also happening. Because as I said, some recent developments that the negotiations is going to hit a, well, I won't say like a dead wall, but Elena, if you could elaborate on that, what was going on?
It's just kind of everything in the AI world kind of just has been a little on the crazy side, considering last weekend's events as well. We'll get back to this in a second. But yeah, in a few words, so the trilogues are underway, and with the December 6th deadline looming, so essentially everybody needs to finish negotiations, European Commission, European Parliament, and the regulators. So, and they can't really come to an agreement. And only the last weeks, Germany, Italy, who was this? Italy, France, and
Germany,
right? Yeah. So I'm not getting anything wrong. So they essentially came out with their take on things, and they do not want any regulation of foundation models. Surprise, surprise. There are a few companies in France and in Italy and in Germany, obviously, that are lobbying heavily for that regulation not to come to pass. So it's been kind of this the main point of just disagreement, and we'll see how it turns out. But today the Commission issued their paper, where they are offering essentially some concessions, and the Commission sort of agreed to withdraw a few points of where they could have regulated and stepped in in some cases. But at this point, it's unclear if it's going to even, I don't know, get off the ground. But as of today, the sentiment is, so they are pretty much adamant. And like I said, unclear. And it's going to be very unfortunate if this will, prevent the EU AI Act from adoption and just finalization this year. And otherwise, it's going to take some more time, which we don't have and which we don't need, actually. So, yeah, it's going to be interesting.
An interesting development was just a couple of days ago, the three governments, Italy, Germany, and France, did kind of come to an agreement themselves between the three of them. That doesn't mean it's been reconciled with the rest of the bloc involved in working on this, but they did come up with this rough idea where they're focusing on foundation models which underpin large learning modules. So what they came up with was mandatory self-regulation through codes of conduct.
Favorite word. Mm-hmm.
For foundation models of AI, which are designed to produce a broad range of outputs, but they opposed untested norms. So it looks like, in a direct quote from them, together we underline that the AI Act regulates the application of AI and not the technology. The inherent risks lie in the application of AI systems rather than in the technology itself. So here they're trying to kind of split how the technology is used from the technology itself and trying to see if they can get more of a, to paraphrase, more like a use-based model of regulation versus what capabilities the technology has. So it's still a complicated conversation.
I have a question, how you tackle it. I'm very excited to be in the room with an ethicist and lawyers. So when you see how the three countries are talking about it, so from a legal point of view, where do you see the shortcomings? So as lawyers, because normally I'm in a room with policymakers or diplomats, and so where do you see the shortcomings? Also, when you say you basically make a distinction between the technology and then the application of it, and then, so what is your immediate reaction as a lawyer? Where do you see the blind spots in this conversation right now?
Ladies?
Yelena, you want to comment?
Yeah. So the thing is, there are, I would say there's a split, right? There are pros and cons of this. Regulate the use, but not technology. And only today I saw sort of like another take was circulated on that. So people are talking about let's regulate that as we regulate. I mean, it has to be regulated, but the question is on what level and how sort of deep and detailed this regulation goes, right? Upstream and downstream. That's what we're talking about. But when it comes to foundation models, the thing that they are so versatile, right? You can apply, and there are so many use cases for that, and can go both ways. Essentially, how do you regulate something that's just a constant moving target? And somebody equaled this to how we regulate guns, for example, right? So there is obviously some use for guns, not in the good way, but just you have to regulate the development, you have to regulate production, and you have to regulate the use of this technology. And I'm of the opinion it should be regulated, not basically on the technical level, not to the extent sort of there's this balance there, right? Not to the extent you just impede the technology and you overstep and you just pretty much prevent the researchers and scientists and everyone from developing. But at the same time, you can't just give up and be like, okay, so let's just regulate whatever the outcomes and whatever the use of that is, and just we'll see how it goes, right? Because it's gonna pretty much go either way. We'll see for the cases, we'll see how people use that technology, and then we'll regulate that. The same time, I think, again, it's important to work out a framework where we actually can do something when it comes to how those foundation models are built, the data they trained on, and the weights that are applied. So essentially on all stages of the life cycle of the large language model, so to speak. But the level of that, the intensity of the regulation and how detailed that is, it's going to be a totally different discussion. And unfortunately, nobody has solid answers as of today.
Well, I think you hit the nail on the head too, because it does get difficult, because when you start wondering about what applications there are for a technology, or you start wondering what the capability of the technology is, trying to choose an either or in that is very difficult, and feeling like you're not constantly chasing a new application or a new capability and trying to figure out, how are you going to chase them in an evolving scenario gets very difficult, especially when law has to be particularly specific in what's permitted and what's not, and making it clear and understandable for businesses. It's extraordinarily difficult to figure out how they are going to reconcile this. But I do think there's something powerful in this, which is we've stumbled onto, this is hard. It's not that simple to just be able to say this is going to be permitted and this isn't. There's a lot of variables in the mix and a lot of concerns. One of them, on the interest of the three companies, it's also even competition, which is, can we set regulation in such a way that we can prevent harms while at the same time still being able to continue to compete with the other companies that jumped out first? There are a lot of competing interests. There are a lot of competing risks. There are competing harms. There's a lot of weighing and evaluation that needs to happen in order to try to figure out where the line is going to be drawn. But from an ethical standpoint, ethics functions well in places where there is ambiguity. It's specifically what it does well. But there's a decent amount of ambiguity here. So one of the challenges is also which nonprofits, which think tanks, which groups, et cetera, are also being able to weigh in on decisions like these. So it's not always just the for-profit companies or the countries or the industries that want to compete, but who actually has a voice for the people who'll be impacted by them. And that includes, as our conversation will move into, the art world, the creative spaces, and where the protections for those lie in between, trying to figure out where these lines are for businesses and industry. There's multiple lines and there's multiple interests that need to be protected. And it shouldn't be, limited only to the impact on the AI companies or industry or tech itself. There's far more stakes in the game.
My question then, following up on what you said, also on the creative world, is then, is it sticks or carrots, also from a legal point of view, right? So you can give carrots in order to regulate beforehand, or then you give sticks. And then what is then, from you as lawyers, is your preferred scenario? Because if you look, that's what last week at the APEC summit, the European regulators were basically scolded, is that they regulate preemptively and without knowing, as you mentioned, knowing even the application cases, and the other way around. Are you then, in order not to hold or stipulate innovation, is it then like a bigger stick then in order to punish misuse? And is it then, because also I'm now speaking from the creative industry, because for a creative, for one singular creative, or whatever, even a company that is doing creative work, is like, where do you go to if your data was misused, right? If your image was misused. So what is the legal, for example, I mean, it's not, I'm not going to hold you accountable, but from a legal point of view, it's just what is the scenario? How is that? Would you think in the short term this can be provided? Because then, if you then provide, basically, if you do not regulate preemptively, but if you give then the sticks, and then if the sticks are easy to implement also for the creative world without going to a massive David versus Goliath trial to prove, which most of the creative agencies or artists wouldn't have just the cash to lay out, just even to go to court, right? And yeah, this is just like on the ethics questions, and also on the lawyer. What is it then that you recommend, just to basically not to regulate, but maybe draw a bigger stick scenario and say so we do not know if this happens, but if this happens, this is going to be your punishment, for example? Or how do you like see, like what is, even in speculative terms, right? How do you get out of this conundrum of this is difficult, this is really difficult, so we're not going to do anything, and no one is getting ahead. So that's my question. Do you want to then draw up a bigger stick for everyone to use, or how does it work in legal terms?
So I'll just quickly jump in. I think regulating preemptively is, I mean, it's not a panacea, but it's much smarter than regulating post factum. Like, let's wait until everything unfolds and happens, the crime happens, sort of like, just call us when you get the body and we'll just investigate the murder type of thing, you know? I don't think that's a good scenario. I think it's important to have like basic standards that everyone agrees are the norm. So murder is bad, stealing and robbing is bad. We can all agree on that, right? So, and everybody knows, if I do this or that, I'm going to get in trouble. So there has to be some set of norms and standards when it comes to AI systems, right? So if they're used for those purposes, I don't know, child pornography, deepfake porn videos and stuff like that, right? We can just, to name a few. So the organizations and deployers and the users, everybody knows that if you go that way, or if your model is capable of that, so that's where you might face something when your technology and your AI system is used in this or that way. So there has to be some basic standard and just a set of norms when it comes to that, so everybody can agree on that. Everybody knows that after that threshold, stuff can happen to you, and there's you have to take responsibility, and there are consequences, legal consequences, because without that, I'm not a big fan of volunteer commitments. I'm not a big fan of just, even if they are mandatory, whatever that means, but it's just, it's obvious to me that there has to be some sort of regulation. What that regulation will look like, that's another subject. But again, at least we can all agree we need a set of like norms for those systems. The system has to be this, and that, and kind of from then on we can just move forward, and all the systems might be different in their own way, but there has to be some, like, you know, ground rules for that. Just, this is common knowledge that this and this cannot go. But since it's so early days, guys, it's been only a year, and you know, just a lot of stuff happening literally every day, and it's very hard to predict which way it's gonna go, right? A few months ago, we were sure the EU AI Act will be passed and finalized this year. Today, nobody knows. It's 50-50, right? So it's unbelievably complicated, and it's gray area, and nobody knows where it's going to be a year from now. But it doesn't mean we need to just, relax, stay still, and be kind of just waiting for someone to mess things up so we can learn from their mistakes. We need to learn from our own mistakes, but you only make mistakes when you're doing something.
Yeah, I have this just perception that the way in terms of regulation might go, I think that I'm in favor of actually categorizing different AI technologies, because right now, I think we see that we cannot simply just put them all in one bucket and say this is how it's going to be. So we'll have to distinguish between, generative AI, and other things, for example, well, that systems that actually have to deal with, product design or like safety and things like that. So what I think might happen, and I think that after the executive order was issued, we kind of saw the list of agencies and, government institutions that will be taking care of some of those things, that are already taking care of them, like FTC, for example, or, National Institute for Standards and Technology, because I work in the tech industry, with software like embedded, systems, operating systems and things like that. So that go onto the device, like onto the Boeing jets or to the, self-driving car. So these types of systems are actually going through much more scrutiny, and they have to get certified. They have to obtain certain standards, like ISO standards, for example. So like for open source software even. So I think that's the way that might go, that certain systems will have to go through this process. And that might not be necessarily the stick, but that might be some sort of a carrot, like, oh, this is certain standard that's going to be implemented, and the system will have to go through the safety certification, they will get certified. So it's kind of, yeah, it's going to be a pain in the neck, because usually the certification process takes a lot of time, but at the same time it's going to be, oh, that might be a carrot in terms of like, oh, we're certified, we're trusted, especially now that certain, at least based on the executive order, certain systems and technologies will have to report to the government, and stuff like that. So yeah, in the creative industry, I think it's good. It's a completely different story. And this is where we might, if you guys don't mind, where we could kind of segue to that, to our next topic, because I know about this, we can talk for, forever, but I also wanted to go to the creative side of things, because that's the whole other area, right? So where people's literally works and, artistic work is being used. And as Christina said, not everyone has that leverage. Yes, we're all entitled to our day in court, but practically speaking, what is going to look like right now, we have like a bunch of lawsuits, and that's how it's being done in the United States, like in the absence of, state or federal laws. That's how it's going to be decided in the courts right now. That's why we're all very closely watching. And yeah, that's why I wanted to kind of go into this. And yeah, this has been on many people's minds for quite some time. And we have this cluster of lawsuits, right, where artists filed lawsuits against a bunch of companies, basically alleging, hey guys, you used our copyrighted works to train your models, for your systems and products, and you didn't ask for our permission, and we think that the result of your actions when you use our images, our works to train your models, and the output that you're creating, that's actually where you're actually infringing, our copyrights. And this is all, I mean, this litigation is still in the early stages. So right now we do have an opinion, kind of a preliminary things that the judge said, dismissing some of the allegations, and actually letting some of the claims to go forward. But we're still waiting on the defendants to actually respond to this latest developments. But I would be really interested in Christina's, take on this, because you have been working with artists for forever, and you have your hand on the pulse there. I mean, what artists are actually thinking? I mean, what's your, I mean, what they're saying? I mean, what's their take on it? I mean, we're lawyers, whatever, but what the real people actually think about this?
So maybe to sum it up, also include the conversation that just happened right now. So last week, I was in several of the events around APEC, and this was so basically the difference of the US and California versus the EU. It's like, oh, when there's no regulation, you just go and do it, and then you just basically Uber. The example of Uber, there was not a certification for that business, so you went ahead and then dealt with the consequences later, right? And businesses be able to deal with consequences later means they have to have that cash flow that actually entitles them, or they have to have the backers and the investors to actually be able to deal with that. With regards to artists, so again, I'm regularly in touch with artists. Yes, when I mean, AI is not new. The idea of artificial creation of imagery, voice, sound, text for artists have been sort of in the near future, but it was sort of distant enough. But now I think within the last year, really extinction scenarios came up in the heads of artists, as in artists, photographers,
Yes.
movie makers, film creators. So I was just on a jury on a prize, on a city prize that is giving up basically initial funding, and I'd say about 1/3 of the people that applied were making movies, and this were the filmmakers using AI. And this was sort of, give me money, I want to do a film using AI, doing that and that and that. And of course, if you look at whatever short film, feature film, whatever, there's a lot of people that are normally involved in that, right? So not even like extinction as the different artists that would normally be involved in each of the steps. This is one major concern because it's a whole industry. And then obviously if you go into the visual arts, and that means photography and people who work with their hands on whatever surface, paper, canvas, and so on, and they did, in order to do market their work, they did take photos and put them online, and this was sort of their material. They are actively worried, and of course trying to understand whether the visual AI machines were trained on their data, so that people can actually use their data and their ideas and their style in order to not even give them a nod, whatever, share profits, but actually use their, it's a major concern. And with regards to photographers, there are two concerns, because over just the last year, as it's estimated, about 200 years of photography history, just the amount were created with AI imagery tools. Just the sheer amount, this of image creation. People, I was in the NFT sector before. Everyone went ahead and tried to do an NFT. Here the same. Everyone, I don't know, not sitting in a hole, went ahead and sort of celebrated their own portrait in whatever style, right? So which gave me goosebumps personally. I understand sort of the childish creative approach, sort of, oh wow, now I can look like a Van Gogh painting. But of course that made me, including professional artists, very worried. And there is, what I asked is like the sticks or carrots. The sticks, like how, give us the sticks, how we can go and actually get the attribution and the rightful part, the share of this AI machine training. So it is really extinction scenarios. Obviously, artists are creative using it in parts of their work. But another thing, so if you talk about actually visual artists, they didn't get the attention. So if you remember the media splash that came out when Midjourney gave, basically when you started doing images in Midjourney, so media was applauding Midjourney. Yes, finally everyone on the planet can create their AI created images. But no one was like, oh, right, they were trained on something. Like the media didn't necessarily manage that. But if you look slightly left or in California further south, the attention that screenwriters and people in the film industry, so they went on strike, and I think the strike went for 2.5 months, and one of their claims and their asks was that there would be a regulated way how scripts are written, that it's humans are involved, and it should be attributed and clear how AI is used. This was discussed, yeah. So Hollywood has basically the bigger guns in order to actually talk about these issues, whereas in the creative, where every artist, in most ways, it's sort of on their own, defending their work on their own right, doesn't get that attention, right? The media is just celebrating Midjourney and then I don't know, on $1 billion valuation versus actually thinking about, or actually like taking apart, like who. It's not that Midjourney just created the images, they actually trained, they were sourcing the data from somewhere in order to, and that is obviously very, very worrying for the creative industry.
Can I weigh in real quick?
Sure.
Few people don't know that, or well, few people know this. You have to dig far back into my profile to find this out. But I worked in graphic design for more than a decade. I've been shooting photography for, well, I don't really want to out how old I am, but let's just say since I was about 17, which was a good number of years ago, decades, something like that. I am a photographer. I am someone who is who's very resistant to putting my work online because I know it can disappear. And when I say disappear, I mean disappear into a data set. I have a collage right now. This is not permission for anyone on this live to go find it and borrow it and use it for any purpose. So let me make that abundantly clear. It is copyright protected. It is on my profile. You have to scroll through featured posts. This is a subject that is very near, dear, personal, and I have to approach it from an ethics standpoint and a tech standpoint all at the same time. So I have multiple lenses that I can view this through. As an artist, I take my work extraordinarily seriously. I tend to shoot imagery related to harm, poverty, lack, exclusion, marginalization. It's not for profit. It's not meant to be for profit. I've intentionally not profited from it. That is a conscious choice. Would I like to see that? Would I like to see that turn up in the data set? Absolutely not. Beyond a shadow of a doubt. As an AI ethicist, I know I also cannot prevent it if it appears anywhere online, even if somebody else snaps a photograph of it and puts it online without me knowing, it could end up in a data set. I also know from copyright law and exploring cases that a judge themselves actually said that the sheer size of a data set or a database may protect a company because it's, quote, simply not plausible that every training image used to train something like Stable Diffusion was copyrighted as opposed to copyrightable, or that DeviantArt users output images rely theoretically on copyright training images. In this instance, we have a particular concern that the size of a data set could actually absolve some of responsibility, also because it's hard to prove derivatives. Now, first, a work is if a work is copywritten the minute you create it. It is not protected by law until you register that copyright. Many people like to say that their work is copywritten, but they don't register it, which means you can't claim harm. Also, in order to claim harm, you have to prove a derivative work. Well, when it's something like a data set with billions of images, how do you know it was one of yours in the pile that created that work, the new work from the AI, and not another work similar to yours in the billions that managed to appear? judges are having a hard time with that. That's causing a huge conundrum for artists, because traditionally, when we say our work is a do not touch, we really mean don't touch it. And we take that very, art is such a personal process. You take that to heart. It matters. It's my vision. It's my view. It's how I want that work to be perceived, whether I want to profit from it or not. It's not just simply up for grabs because I put it somewhere, especially when I put text with it that said, don't touch it. But the problem is when you scrape for images, you don't take the text that goes with the images. You just take the images. So it's separated from your copyright statements if they're not embedded on the artwork. So some people have talked about glazing, copywriting, embedding things, putting layers on artwork. They failed consistently when people have tried to, render them pointless. And they've been successful in rendering them pointless. That, once again, leaves artists' work vulnerable of any kind. So what do we have? The thing that I've got the most faith in as a creative right now, out of all the options that we've seen, is the FTC and their concerns about fraud. Portraying my artwork as your artwork is fraud, or should be. Let's hope they can get there. Claiming that you created something that you didn't alludes that you have skills that you do not have, which is also falls under things potentially, and I'll allow our lawyers to get into this, but potentially to fall under things like fraud protections through the FTC. The other benefit of the FTC is that, regular people like us don't have to spend money to pay an attorney to investigate it. The FTC, you can file a complaint with them and they can investigate it themselves, eliminating that roadblock. Does it solve all the problems? Should I have to go through the FTC to protect the people that are photographed by me in work that was meant for a specific purpose, for it to be taken outside of that purpose and used otherwise? No, I shouldn't have to do that as an artist. But sometimes we have to do things we don't want to do or that we shouldn't do. But I do think it's time to recognize that there's a certain misrepresentation in claiming artwork that you did not authentically go through the evolutionary process you go through as a creative to create that work. One of the strengths of work is that it comes with history. The photograph I took a year ago had decades of photography behind it. It's a part of a legacy of my photography and an evolution of my understanding, not only of my subjects, but of my craft, of my capability, of my eye, of my experience. To just simply make a copy of it, new and improved, and adding some stuff to it, it doesn't come with that same legacy or that history or that genesis, the act of creation that went into the pieces that Midjourney is putting together. And I think that that does a tremendous disservice to creatives, both from an ethical standpoint and from a creative one. I think the FTC is on the right track. If we can't get copyright to bite, let's hope the FTC can. Because right now, if the judges are going to side on the size of the data set, then all a company needs to do is make a bigger data set. And that can't be the answer for people doing work like me, with people involved in work with Christina. It simply, it doesn't represent what art is. It doesn't get to what's involved in the craft. It doesn't honor what it took to get here. I've been traveling to impoverished areas of cities for decades, walking among the people whose photographs I shoot or neighborhoods I shoot. You can't just piggyback on that and borrow that legacy or that history or what informed my eye to take that photo. So I think we need to do far, far better for our creative community. And I think we need something that has teeth. But I'm going to have to turn it over to the attorneys to tell me whether or not artists just might have some hope in concerns like things like fraud. Ladies, it's up to you.
I'll just, Elisa, go.
Yeah. I mean, these are all good questions, Laura, and I think they're the reason why these lawsuits are coming about. I'm not listing the slides, but there are all kinds of claims, right? When people, because basically it's so new, so they're basically kind of throwing like everything in. It's not just copyrights, there are other things as
Right.
well,
Absolutely.
and what we're seeing right now is that how judges going to look at that. But
Trying
yes,
to
you're
sort
right. I
it.
mean, there are other avenues to pursue, and I also wanted to kind of switch over to the writer's side as well, because it's not only the artists, the imagery as well, but it's also literary works,
For
right?
sure.
And this is where I think Christina is right. So that side got more exposure, is because we know these people, they're famous,
Mhm.
movies are
Mhm.
being directed based on their novels and things like that. So yeah, and it's again, we're gonna see how that's gonna play out, and we don't know. But I think the major, I think, counter argument from the defendants is that you know um the outcomes, the derivative works, to speak, there are none as far as I understand, because you have to show that here's your original work and here's the derivative, and there's like this substantially similar, right, factor, and it's kind of a hard to prove that, and we haven't been through through all that litigation just yet to see how the size is gonna what they're going to do in that regard. So and I also wanted to like quickly just to demonstrate, for example, what Japan is doing in that regard. So it's interesting because their government actually came up with this just in May, came up with this kind of paper, explaining that AI generated art might be subject to copyright infringement. And it's the interesting thing that they actually differentiate between, learning and research process when you're taking copyrighted works without permission and just use them for learning and research and not doing anything else. But if you're kind of a transitioning to the next phase when you're generating images and artwork using AI technologies, and then you sell them when you monetize, then you're in the red zone. So it's interesting. I mean, it's just something that I kind of found doing the research for this talk, and I was thinking, this is interesting. It's like they're kind of putting their emphasis on monetization as opposed to, like, maybe, Laura, you would be okay for using your photograph for a research and development, whatever that means, but you would not be okay for them to create output based on that learning data set and actually selling, like Adobe, I think, selling some of the images right now. But yeah, so this is kind of that's another maybe way that could go. But in the United States, I think, as we all know, legislation takes a lot of time, especially federal law, and good luck with that. So it's going to be, I think, at first decided in the courts, and we just going to see how that plays out. But yeah, we don't know. And I think that um, we also wanted to touch briefly on this, and I couldn't resist taking this Game of Thrones image and throwing it into the slide deck because, yeah, George Martin is suing OpenAI, so let's just put Jon Snow up there when we're talking about copyright shield. So I am the shield that guards the realm of man, whatever that means. So basically, I just went and researched, OpenAI, Microsoft, and Google Cloud and Workspace indemnity provisions for whatever. Basically, what they're saying right now to their business customers, as far as I understand, it's like, we will, if anything happens, if someone brings, claim against you, lawsuit, we're going to protect you from that. We're going to pay for everything. If you're challenged on copyright grounds, we take all responsibility as long as you use our products in accordance to certain policies, responsible practices, and things like that.
Yes.
So this is also something very interesting, and I think that right now, I guess the companies are seeing so much value kind of in what they're doing, is that they're ready to indemnify their paying customers because they see it's still going to behoove them, by them I mean the companies, to to use this data as opposed to people suing them. So I guess they're just doing this like risk mitigation. Their risk mitigation strategies is just we're gonna step in and take care of all this litigation. But for us right now, in the absence of regulation, I guess we're still gonna do whatever. That's how I read this. But I don't know. Maybe you have a different take on this,
I
because
do.
this is yeah.
If the size of the data set protects them, then there's no risk in them saying that they'll handle the lawsuits. They just walk in and say our data set is this big. It's no
Right.
skin off their back. They're taking responsibility for something that it feels like they don't have to take responsibility for, but they already know what the out is. So as long as this case and this judge's comments, which I'm sure have been echoed by others, but I only have the one quote, as long as those statements hold up, it really doesn't cost them anything. They already have attorneys. They already know the copyright issue is an issue. All they have to do is walk in and say, mine is this many billion. And it's a get out of jail free card.
It might be.
So if it works that way, then it makes users feel more comfortable because they're not independently responsible. But the generative AI company isn't either, because they can just say, this is how big the data set is. You can't prove which of our 4 billion pieces fell into to make that one. So you can't hold us accountable, and we've identified the other people. So the only way you can get to us is through us, and well, we're bulletproof.
I was gonna say it's like it's a very business move, you know. It's a foolproof plan essentially. We cover volunteer commitments. We're just pretty much stepping in. We are covering you guys, lawsuits, whatever you name it. Plus, we'll ensure our customers keep using our product
Absolutely.
because everybody's covered, you know. And regulation, yeah, litigation, kind of it's gonna take years probably for us to kind of get some sort of result. On that note, big fan of FTC and whatever they've been doing in the space, the inquiry and investigation into OpenAI, with the data leaks, right? Their comments on the USCO, US Copyright Office inquiry. So at least someone is sort of just stepping in. At least we can hope we'll just have some sort of redress, right? If not solid regulation. But on that note, I think it's a very, again, coming back to this, it's a very business move, thoughtful move. So we'll just cover our bases, risk mitigation, like Elisa mentioned, you know, all around, everything is nice and cute. We look like the good guys. We've got your back, and, you know, just feel free to use our technology and we'll see how it goes. But essentially that doesn't change the fact that there's still no regulation and nobody knows where we stand with AI generated art and copyright, right? I mean, the US Copyright Office obviously is clear that AI cannot be the author of the work. And whenever anyone is filing an application for copyright registration, you have to disclaim that you used AI in order to produce the work. On that note, how many people are disclaiming that? Everybody? We don't know. There's no way to check, right? We can only hope for the fact that they are being honest. And again, businessman are businessman.
Chiming in on the art side, I think artists take pride in their craft and art. So I think artists that are experimenting, they are very vocal about if they use in part of the process AI. So that sort of makes artists, trained artists, also, so to speak, hobby artists, but still they take pride in their process because it is not clicking a button and giving a couple of prompts and then it spits out. But if you actually take to it, it's a whole process. So hobby and professional artists will be very vocal about it. So I think that's the on the artist side, I think that's the benefit of it. Yeah, but coming from startup world, it's also this protection shield of saying we will take over claims. I mean, if you look at the companies who have that shield, it's the big ones, right? So, and we look now at a quite long tail of startups that are working in AI that are not billion-dollar companies, that are not valued at that, and that have very specific use cases. So I think this is also not in the idea of the creator, as in of any mighty creator, to distinguish between these are the big, basically market leader. They can afford taking on law and litigation like that, versus smaller startups that are in the growing phase will have problems with that and will be more vulnerable. They cannot, most of the time, I would say and assume now, take on that part. So I think that also creates a significant imbalance in the ecosystem of people actually trying to put products out there for a multitude of users and end users.
Yes. I think that's right.
Yeah, that's true. I mean, we don't have a lot of time left, so I know that we've been talking about what could be the protections for the artists, when someone is using their works in a data set, and how that can be, regulated, or somehow how we can help them. And I mean, we just have a few minutes, but maybe we will have a few minutes just to cover that, because I think that also matters. And just knowing what kind of initiatives are out there right now that could actually mitigate some of those concerns. And there are certain projects out there, and that actually people are working on tools that could actually actually detect AI generated works. And all kinds of things are being proposed. And watermarking, for example, or some other AI detectors. There's actually a bunch of them on the market right now. So this is something that kind of on the other side, and helping the authors, that could also be something that we will see proliferating or not. And how all of this kind of a technical kind of area gonna kind of fold into that legal framework or something like that. So maybe some of the guardrails or standards that will be put in place, for example, you'll have to use some of those watermarking or whatever tools, things like that, or will be some tools at your disposal where you could detect. So I don't know if you wanted to comment on any of those. Is just kind of to put it out there, because these tools exist, and I think they've been there for some time. So, but how successful they're going to be in the long term, that's remains to be seen.
Yeah, I was just gonna say that quickly. There are a lot of those a lot of companies who are offering the service, right? Will watermark, and we are detecting AI generated content, but how accurate are they exactly? Is again, you can trust them completely, right? And there will be consequences. Again, there are it's good to see people are trying to figure out how to how to, at least they're trying to do stuff. They're trying to figure out how can they mitigate the risks, how they can help artists in any sort of way, or just people who are concerned where their data, their works go on the internet, right? There are ways to track it, but again, I would stay sort of just cautious, and I wouldn't blindly believe that all those tools are 100% correct all the time. So again, early days, and everybody's trying to figure out stuff as they go. Regulators, artists, creators, pretty much everyone, the companies, and it's this balance that everybody has to find for their company and for their situation, I would say. So and I see it's 4 p.m. That means,
Yeah,
unfortunately, we have to stop. Do we? Do we?
right.
Do we
Yeah,
stop?
we haven't. Yeah, we haven't. Yeah, we had another topic that we wanted to discuss a little bit about the deep fakes, because it's kind of a related one. We have a few actually bills. One is in the works right now in Congress. A couple of others that actually has been signed into law within the last 2-3 years, about people's liking. I mean, their faces, their digital replicas, and things like that. So maybe we'll talk about that next time. But yeah, if any other last comments that you would like to make, and before we wrap things up.
It's just, I've been in the last bubble. I've been in the crypto and NFT bubble as an entrepreneur. And when the conversation of NFTs came up, this was far before the hype for it. The idea was royalties, the idea was protection. So basically also copyright protection, that you have it on chain, that you can protect it. Once the speculators got the hang of it, the whole space was populated not by the artist. The whole purpose of that idea of the application, the real world application, was taken in a different direction. Everyone went to do NFTs. People were eager to cut out royalties. So 5 years from sort of the initial NFT conversation to now, royalties are dead. NFTs are being talked about as if they're dead. And this is not because the artist didn't want it, because there's not an application. There is still an application case for it, but it was taken hostage by a whole different conversation. And the problems that are underlying it and the legal aspects of it are now just being tackled, securities and so on. So my hope is for AI as the big wave that we are in right now, that the eye-level conversation of needs of real, that's why I love the real life part of your conversation, is that it's now maybe learnings from the last waves. And I guess there are waves and waves of entrepreneurs that have been going through, that the learnings of these waves can be taken into account when creating faster and really structures for the individual that is providing into these data sets, but in a smart and just, as in who's the artist, when was it done, etc. And in order to forego a bubble and then a bust, and with nothing coming out of it, with again sort of a desert for the ones who are mostly affected. That's my last comment on that. Thank you for having me.
Thank you so much,
Yeah,
Christina.
thank you so much, Christina. Yeah, I mean, it's always like that. We start with some topics and then we leave kind of one topic for later.
We veer,
Because-
of course, completely.
Yeah, because it's such a, I mean, it's not possible. We didn't like even touch on all this like open AI soap opera that's happening right now, because it's like every 3 hours there's something. So you kind of have to pick and choose what you want to. But yeah, I mean, we were trying to really stay away from the legalese and all this complicated jargon that's everywhere these days, and just kind of, focus on what it means for just a person that has a laptop and doing their work and trying to, you know, pay bills and stuff like that. So yeah, so I hope I hope we can somehow achieve this goal, but we'll keep this series going, and I think next time we might start with the digital replicas and people's, you know, their personas actually, because this is actually intellectual property thing, right? So and we already have laws in place for that, but it's going to be interesting to see like how that, and I think that's a huge problem in terms of children's safety and, you know, minors and all of that kind of stuff, because this is super scary. Like for me as a parent, it's like I can't even imagine, like I don't want my mind to go in there with all this digital replicas thing and the deep fake stuff and stuff like that. So that's another something that hits very close to home, I think, for many folks. And we just have to educate ourselves. Doesn't matter if we're lawyers or not, or like business people. This is something that will, I think, might affect. Right now, it's all in the entertainment industry, I think, because again, it gets a lot of exposure. But when it comes to all of us, how that's going to affect us in the long run, if that technology is going to proliferate. So yeah, that's an ethics question as well.
If you're not famous, right? Do you even have personality rights, right? It's like, does anyone even?
You do.
No,
your likeness is your property.
I'm just saying, like, does anyone like even care, right? Would people, would papers write about it? Of course not. It only kind of gets picked up if just someone like some celebrity has been, you know, their likeness has been, like Tom Hanks, for example, right? His likeness has been used for those like commercials and stuff. But for example, in terms of just if we're talking about everyday life and everyday people, would you know,
for example, if you are, I mean, I'm a movie aficionado, right? I love watching movies. Would I want to see a movie with a digital replica of my favorite actor, or I don't want to spend my money on that? You know, that's also as a consumer, like, do I want to see that, or I do not want to see that? Because right now, I think the technology is moving into that domain where those things can be possible, right? So do I want to see that or not? So that's another question, you know. Yeah. So yeah, we can.
Can we finish?
Yeah. I think I think we can wrap this up. And thank you, folks who attended online. And I think we have some questions that we'll try to answer. And the resources reading list is usual for you for the holidays. And I guess happy Thanksgiving for all who celebrate. And and thank you our speakers for joining us today.
Thank you.
Thank you.
Thank you. Happy holidays. Bye.